If you lost your case at the Ccma or bargaining council, what are your options? Hi, my name is Aslam Mullah and I am a registered attorney. We get quite a few inquiries from employees who have taken the matter to the Ccma on their own. The company came with a lawyer and they were bamboozled, and as a result, they didn't win the case. What are their options? Did you know that both the employer and the employee are able to take an arbitration award, either made by the Ccma or bargaining council, on review to the labor court? What does that mean? That means that you can have the decision looked at by a judge from the labor court. However, you must be able to show that there was a defect in either the proceedings, the way the case was run, the award that was given to you by the Ccma or bargaining council. Now, what is the definition of a defect? According to the Labor Relations Act and various case law, a defect is defined as 4 specific situations. Any one of these 4 situations will apply. The first is where the Ccma or bargaining council commissioner had committed some kind of misconduct in relation to their duties as a commissioner. And what this means is that, for example, the commissioner didn't give you a proper chance to speak. They allowed the other side to speak. When it was your turn, they refused to listen to you. That would be considered as an example of a defect in relation to the first ground. The second ground is that if the commissioner had committed a gross irregularity in the conducting of the proceedings. For example, where the commissioner allowed certain types of evidence, such as hearsay, be a critical factor in the decision making when it should have had less weight. The third ground that can be relied upon at the labor court is where the commissioner had exceeded their powers. For example, they did something they were not supposed to do in terms of either the Ccma rules or the Labor Relations Act. And the last ground is that where the award was improperly obtained. In other words, there is an inherent bias or a perceived bias in the way the proceedings were being run. An arbitration award can also be reviewed if the decision reached by the commissioner is such a kind of decision that another commissioner who was sitting in the same position would not have reasonably reached that decision. In other words, that decision was just so absurd that any other reasonable commissioner would have looked at the situation differently. In summary, an arbitration award can be taken on review to the labor court. However, you must be able to show specific grounds on why the award should be overturned. If you need help in your situation, whether that's going through the arbitration award to see if there are any good prospects on succeeding at the labor court, or help with drafting of the papers for labor court, or an explanation of the process at labor court, you're more than welcome to click the link below and book an appointment with our office. I wish you all the best, and I'll speak to you soon.